Oh, 2 people, actually. Okay. Okay, so thank you everybody for joining in and being here on time. Again, just like yesterday, just for our safety and to be cautious, our cameras for our participants are going to be off until Q&A time. You will be able to unmute yourself and turn on your camera and ask some questions of the presentation. So here I will pass it on to Jim.
Good morning, everybody. Thank you for joining us. Being willing to sacrifice some hours out of your day. This is being put on by NAMI Urban Los Angeles. I want to thank Mr. Harold Turner and, of course, Farell, who is the webmaster for NAMI Urban LA. She's here doing all the hard work behind the scenes, operating Zoom and so forth. So we really appreciate all that they're doing. We also have Guillaume, who is going to be one of our speakers today, and she's actually joining us in the slide presentations from the Department of Mental Health. And of course, Gail Evangueletti and myself, Jim Farell. Gail focuses primarily on Los Angeles. I'm from Orange County and also a member of NAMI Urban Los Angeles. So some of these slides may reflect a little bit of both counties. What we're going to do today is to talk about the various rights of conservators who are pre-existing conservators. And we're also going to present quite a few resources. The resources, of course, because it's NAMI Urban Los Angeles, are going to focus on Los Angeles, but the laws, the rights are universal throughout the state of California. So once you're through this meeting, you'll have a better understanding of some of your responsibilities and your rights and so forth. So we're going to start right now, and I hope you enjoy our presentation. Farell, next slide, please. So we've covered this, and okay.
Covered that too.
We covered these. We'll get there. Very important, and I didn't cover on this, is that Gail and I are not attorneys, and our presentation is based on what we've learned from others along the way. We share what we've learned, we make suggestions. You are going to make the final direction and determination of how you're going to pursue your conservatorship. We present laws and so forth to help you, along that journey. And even though we're not attorneys, we've had several public guardians, both from Los Angeles and Orange County, attend these presentations, along with some LPS attorneys that specialize, of course, in mental health laws. And they have not found anything that is incorrect. In fact, some of the attorneys were just amazed at some of the things that Gail was providing in these presentations. It was their learning curve as well. So we're going to go ahead and start now on the next slide. So as a conservator, it's critically important that you always present yourself as the conservator when your loved one is being put into the hospital, or if you're calling the CAT team for a response, if they're arrested, or whatever the situation, you'll always refer to yourself not as the parent, but as the conservator. That distinguishes your rights and the rights to know everything that's going on with their medications and so forth. You want to take also you'll want to take the free NAMI to families classes. NAMI Urban Los Angeles does a really great job on that. There's a lot to be learned from that. And other tips are that you'll want to keep journals on medications, how long they were on it, your personal observations as to how you feel that they were doing on those, any side effects that you notice and so forth. And dates, of course, are very important in all of that. You want to keep a record of everybody you talk to about your conservatee, whether it's Social Security, it's the doctor, or anything else. Keep notes. They're very important, and it keeps you on track with what's going on. And it's really important for medications as well, and we'll talk about that a little bit later. Next slide, please. Okay.
Okay. LPS Conservatorship is the term used in California. It's named after three legislators, Latterman, Petrus, and Short, and it's from 1974. The laws are really old. They're really not bad. It's how it's been implemented throughout time that's been difficult, because it should be easier to get a conservatorship. It's kind of a quick and easy way to get, not easy, but it's a quick way to get your loved one back on the road to recovery and give them back their lives. Other states use other terminology, and I mentioned yesterday, Florida used Baker's Act reform. Louisiana, it was an interdiction. Most states use conservatorship or guardianship. You do not want a guardianship in the state of California, because the way it's defined in the state of California, you would be liable for their finances and anything they do or don't do. As a conservator, an LPS conservator, you are not liable. An LPS is strictly for serious mental illness. And of course, you know, they may have to meet two criteria: have a serious mental illness diagnosis and be considered gravely disabled. Unfortunately, these laws are over 50 years old. They don't reflect the current scientific research in treatment for recovery. And for instance, medications, the newer medications really do help people to get their lives back together with quality of thinking. Okay, next slide. The forms of conservators. The booklet that you should have gotten when you became conservator, and you can look it up online if you didn't get it, Helping Your Loved One, which is a family guide to conservatorship and involuntary treatment. It is on the internet. I would strongly suggest you look it up and print it. It has a lot of things in there. It has a form for the doctor's declaration when you're ready to renew the conservatorship. If your loved one wants to drive, it has that form that you get filled out by the doctor and give to the court. It has a lot of information. It's really one of the best books I've read. Next are pamphlets. Next slide. The essence of your LPS conservatorship is to mandate medication. Everything else is temporary, but mandating medication is the essence of it. Without that, you really don't have a conservatorship, an LPS conservatorship. And when we refer to conservatorships, we're referring to the LPS in this program, not probate conservatorship. Probate's for everything else that's not a serious mental illness. Next slide. Okay, the types of LPS conservatorships, you have it of the person and of the estate. The doctor at the treating hospital will initiate the conservatorship of the person with the public guardian's office. The public guardian office will do their research, and they will petition county council and the court for a court date if they approve that this conservatorship is needed. And they're really quite good. The moment that information goes from the doctor to the public guardian, call and find out who is handling the case, talk to the person. If you want to be the conservator, let them know that at that time. And they will do all the research to find out if you're qualified. It's really not that big of a deal because they really want you to be the conservator. Keep in mind, a public guardian can handle anywhere from 50 to sometimes 70 people under a conservatorship, which is a lot. You're handling one. So when they're doing it, they're very busy. If you choose to have the public guardian as a conservator, please be respectful of their time and understand you're not the only one. So when you pick up that phone and call them, know what you want to ask and get off the phone. They really don't have that time. Now, if you need a conservatorship of the estate, it's a public guardian that you can ask about that. And give them, you can do credit karma or to find out what debts they owe, if they have school loans, if they have court papers that have to be done, whatever their needs are, you can inform the public guardian and they will request that you be conservator of the estate. When you go to court, this is really important, ask to be assigned an attorney. The attorney is your attorney that you can use for the entire year, and they don't charge for that. So if you have any questions, maybe filling out the forms for SSI or anything, that attorney, you can call them. They should be able to help you with all that information. But if you do get the conservatorship of the estate, and if they have a lot of debts but no money to pay it, you can call them and call the creditor, let them know, hey, they don't have the income to pay for this. They're under conservatorship. If they file a judgment, don't freak out. That judgment will only stay on the record for 3 years. So that should, after 3 years, it should be gone. I think that's pretty much it on this. But if you do pay debts off, negotiate with them, 10 cents on the dollar, 25 cents on the dollar, whatever you can negotiate. And they're pretty good about negotiating. Be sure if you do that, you tell them that you want a statement that this debt has been paid in full. So they don't come back later and say, well, you still owe some more money. All right, next slide.
Succession of conservatorship. The conservatorship can be changed from the public guardian to a responsible party anytime during the year. Sometimes what happens when we're appointed, we'll get calls from families or other loved ones who'd like to become successor. That means take our role as the conservator. What we'll do, we'll let the court know, we'll interview the person to make sure they're appropriate to become a conservator, and we explain to them what it means to be the conservator. And if we, the public guardian, think that they're appropriate, we'll contact the court and let them know that we're recommending them to become conservator. And just like we can appoint a successor, the court, for whatever reason, sometimes loved ones, they get overwhelmed, something happened. A conservatorship can change from a private conservator also to go back to the public guardian. If for whatever reason you need to resign as a conservator, you can write a letter to Department A in Norwalk and ask the judge to appoint the public guardian as a successor conservator. And you must remember that the court will honor the conservatee's request the best they can. A lot of time, especially at the initial conservatorship, the conservatee will not want their loved one, a parent, a sibling to be conservator, because at that point, they're still the enemy. So the court will let the public guardian be appointed, but later on down the line, there could be a successor. Who should be conservator? It starts off as the public guardian. We're always appointed as the temporary conservator. As the public guardian, we're able to place person in a state-approved facility. Less stress for the family. The negative impact is less, and the family is less involved with the recovery process. Family has no control over medication, and the family has to work to establish a relationship with the public guardian. Should I become conservator?
Wait, I'd like to add something to that.
I'm sorry.
Those that didn't hear yesterday, the meeting, when you're working with the public guardian in Los Angeles, they're very good, and be respectful of them, but they will work with you. We're blessed because Los Angeles has some really good public guardians. Just wanted to add that little bit.
Thank you.
Okay, so in trying to determine if you're wanting to be the conservator, the process has gone through, you've been contacted, and they're now contacting you, and it's the public guardian's office that will contact you, and they will ask you if you're wanting to be the conservator. So what are the pros and cons of being a conservator? Well, first of all, the upshot is that you have direct contact with the doctor. You'll be able to discuss medications with them, make recommendations. If the doctor prescribes something that you don't feel is beneficial, you can work with the doctor and explain to the doctor why a certain medication may not be the best, and that you've seen better results on another medication and so forth. You can reject inappropriate treatment facilities, medications, and treatment places. Again, when it comes to rejecting what a doctor is going to prescribe, you want to be tactful about that, because if you just say, well, I don't like the medication, I like this, I prefer the other medication, I think it's better, that doctor can have you removed as conservator, because he'll represent themselves as the professionals and you're not. So you want to work with them, but you will have that opportunity if you're the conservator. The downside is that your conservator is always manipulating you, wanting more money, wanting you to do things or give them things that you don't really want to give them. And sometimes they can be relentless. So that's a lot to contend with. The other side is that the hospital will try to push you around and discharge the patient to a facility not appropriate for the level of needed, or rather for the treatment level that's required or that you feel is required. So stand firm on those kind of things as a conservator. But again, these are areas that you're going to have to deal with. You may also, as a conservator, have to take time out of the day and go down and sit for 2 or 3 or more hours at the Department of Social Security, waiting to speak to somebody directly for appropriate changes in the funds or other issues. Marie, do you want to add to that? I should have let you have the slide. I apologize.
No, it's okay. Yeah, well, as a public guardian, as a conservator, I think we have an easier time saying no and being firm with facilities, because we've been doing this business forever. So Jim is right. I mean, we see it sometimes that families do get manipulated by the conservatee, and that's because they love them and they try to make them happy, versus it's the public guardian. It's more in the objective type of relationship where we know, no, you're not getting extra money, because no, we know you're going to go get drugs or do whatever you're not supposed to. And we kind of know the hospital tricks. Like, we know when they're trying to discharge someone, when the person shouldn't be discharged, we object, we do whatever we have to do. Versus I know we see a lot of time the hospitals may trick family into discharging their loved one when they're not really ready. So it is there's a lot of pros and cons in who's conservative. Next slide. So liability of the conservator. Welfare and Institute Code 5358.1, you are not liable by law, liable either civilly or criminally for anything the conservatee may or may not do. You are not financially responsible for the conservatee's death. And also remember, while your loved one's under conservatorship, if they go and get a credit card or what have you, you can go back and show whoever gave them the credit card, the phones, because this is what we see a lot, that this person's under conservatorship and cannot go into contract, and they must undo it. Next slide.
Wait, hold on. That is
sorry.
a really good. Yeah, on that liability, you aren't liable for anything, but if you are negligent, for instance, they will temporarily suspend their driving rights. But if you give them the keys to the car and say, could you go to the store and get some milk or something like that, and they have an accident, you are liable. If they took the keys without your permission, that's different. So then you are not liable. The other thing is the hospitals will want to put them in a facility, and they're going to want to charge you, or sometimes they want to charge you for hospital stays. You are not liable. So don't let anybody push you around and say that you owe them money, because you don't. This person, all you are is a guide approving and disapproving treatment, placement, and medication. And that's it. You're not responsible for anything. All right, next slide.
So when it comes to the rights and responsibility of the LPS conservator, know that you have the power to approve or disapprove of all medications, treatments, and placement. As I brought up a little bit earlier, when it comes to medications, you have to be careful in how you approach that. You want to work with the doctor, you want to make suggestions, you want to share positive results, but you need really good credibility in what you're telling them. For example, let's say some folks are allergic to Haldol. And you say, doctor, I know you are suggesting Haldol, but our son or daughter has an allergic reaction to it and it causes the airways to shut down. And that does in fact happen to some people. The treatment, the placement and so forth, again, you have the right to go to that facility prior to your loved one being put there. And if there's legitimate reasons, let's say that they're co-occurring and have a substance abuse issues, you get to the board and care and whoop, right down the street, there's a pot shop, where they're selling all sorts of drug paraphernalia, or they're selling, it's a marijuana dispensary. You'll say, no, that's not appropriate for my family member, for my conservatee rather. So these are your rights. Work well with the doctor and you'll be fine. These are your rights. Next slide. Ray and Gail.
Okay, conservators have the right to speak directly with the treating doctor. I always let our families, the families who are conservator, I always encourage them to participate in care plan meeting. If your loved one is at a facility where they hold monthly or quarterly care plan meeting, ask them when that's occurring and ask to be part of it so you can help make those decisions. You also have the right to apply for SSI, SSDI, Medi-Cal, and Medicare. You can have private insurance, Medi-Cal, and Medicare all at the same time.
I think she covered it pretty well.
Next slide.
Okay.
Oh, I'm sorry. Go ahead, Gail.
Okay, California Welfare and Institutions Code 5358.5 helps you if your loved one decides to go off the medication or for some reason it's not working. This is the big one that everybody will maybe need. It gives you the right, when you deem it's necessary, to put the person back in the hospital. When you deem it is necessary, do not wait for them to become harm to self, harm to others, or quote, gravely disabled. Your responsibility is to keep their recovery on a forward motion. So let's say a week's gone by, they refuse their medication. We have Marion Brown, you see at the bottom. Now this is for Los Angeles. You can contact her. She's the deputy for emergency outreach, and you can tell her what the problem is. She will arrange to send the CIT police and an evaluator. They don't need an evaluation though, because the court has deemed that they are gravely disabled and nobody can say anything different, just the court. So if somebody tries to say, well, they're not gravely disabled, they are in contempt of the court. So at that point, because they're gravely disabled, they can transport them to the hospital. If you do it early enough, the person hasn't gone down so far that they can many times just give them the medication and send them back. If you wait for them to really decompensate, then they may have to stay in the hospital longer, or they may have to wait to go to an IMD. And IMDs can take 4 to 6 months in the hospital before a bed becomes available for them. So you really don't want to wait. It's quick and easy. Well, it's not easy, but it's quick to get them in the hospital, get them back on their medication. And once you do that once, they usually will stay on the medication because they really don't like those police rides to the hospital. Okay. Go ahead, Jim.
I wanted to say, like on this first part, it said, as conservator, you have the right to hospitalize. You actually have the same legal rights as a police officer or a mental health care worker in terms of placing your conservatee into the hospital when you feel that they need to be there. That being said, how do you implement that? The police department will come out and they are not going to go hands-on to assist you in getting them onto a gurney anymore. It just seems like that's the real direction that's being handled by the police departments nowadays. And as well, I've actually experienced a police department to come out and they'll want to do an assessment on their own, and all of a sudden they they have determined, no, he doesn't meet legal criteria. And it just tells me that they don't really understand the laws. They don't understand that, and this is why also you will want to keep your mental health history available to help in that process of trying to get them hospitalized. You have the rights. It's just not always easy to implement them or to get the assistance you need to get your loved one in the hospital. Okay,
And
I just wanted to add that.
And I just wanted to piggy right up of that a little. The buzzword that we use at the Public Guardian when dealing with the hospital or law enforcement is, as the conservator, you have the authority to authorize detain and treatment of your loved one or of your conservatee. You shouldn't even say loved one, of your conservatee. So always remember you're authorizing detainment and treatment of your loved one.
State that you're
Well, I like
authorizing it.
Detain and treat, the two buzzwords. As a conservator, you can authorize them to detain and treat. We actually have a form at the Public Guardian that's called an ADT, and it's called the authorization to detain and treat. And that's what we send to everyone when we find out that our conservatees are either hospitalized, arrested, or what have you. But detain and treat is your right.
Miriam, could you, Marie, I'm sorry.
Mhm.
Can you send me a copy of that and we'll put that on the slide and we'll also put that in that guide for conservators.
Sure, it's called the ADT.
Right
I'll send
now-
it to you.
Thank you. We've been contacting Miriam Brown and she pretty much takes care of it. But if we're on a weekend, they're not there on the weekend. And
Mhm.
sometimes we need it on the weekend, but I like that. I didn't realize we had that. Thank you. That's why we have
Orange County. That's awesome.
This is why we have the Public Guardian with us, because she always has extra information.
Great.
Okay, next.
Gail?
Okay, California Welfare and Institution Code, that 5358.5, same as above. The conservatee by court decree is gravely disabled. And as I said, nobody can say that they're not, because they will be in contempt of court. So you can request police transport when you deem it's necessary to a hospital for treatment. The hospital is the only place where they can force medication. If they're in an IMD, board and care, or anything else, and they decide to go off their medication, those facilities do not have the power to force them to do medication, just the hospital. That's why we have to have them transported back to jumpstart them back on their medication. And once you jumpstart them, it's pretty much, they're not going to do it again. It was rare. In fact, I haven't heard of anybody doing it a second time. One time is pretty much all they want. Jim?
I think you're pretty well covered it. We talked about the fact that we can ask for police assistance and some of the challenges therein. But there again, the hospital is the only place that medication can be forced. The conservatee does not have the right to refuse those medications. And yet, a board and care or a conservator or family member cannot force medications on the conservatee. Only a hospitalized individual in a designated hospital can do that, actually. Okay, and that's about all I'm going to throw into that as well.
Okay.
So CalAble is a agency. It's part of California's agencies, and it's a place that allows you to do a number of things. Primarily, it's a place for you to establish a savings account for your loved one that could be used down the road. If you have a special needs trust set up, and of course, you might counter that with maybe there's better investments, or maybe it's a whole life insurance policy that would fund that better. But these funds can also be used in the current time. For an example, if you were to pay the expenses at a board and care out of your own pocket, because maybe the amount of Social Security funds is not quite sufficient to pay the whole rent, and you were to pay the rest, there's things that you cannot pay for and that might cause them to lose their SSI benefits. But through CalAble, you can deposit the funds there, and then through the CalAble account, you can use those funds to pay for actually a whole host of things without jeopardizing the government benefits. You go to calable.ca.gov and look at expenses. In fact, let's bring up the next slide. I believe it's going to show you some of the things that the CalAble funds that you put in there can be used for: education, housing, transportation, assisting with their employment efforts, just a whole host of great things. You can buy them a computer, you can pay all those things. And some of these, especially like the housing, are areas that you're not supposed to be paying for. You can do these, you can pay for these expenses through the CalAble funds, and there's no problem, there's no challenge on that. Okay, next slide. Cal?
Okay, the LPS conservatorship of the state, and I talked about this earlier, you can negotiate debts, you can handle criminal court cases. Oh, you can acquire a waiver for school loans. So if they owe $10,000 in a school loan or $20,000, you can request a waiver. Now, if you do that for the next 3 years, they cannot earn anything above poverty level. And most of our people aren't going to be doing that anyway, because they're going to be in treatment for about a year. They can still get a job, but they're not going to be an executive or a CEO of some major company. And if they are, God bless them, they can pay off that school loan. You can cancel credit cards, and that's supposed to be cards, not cars, but cards. We keep forgetting to correct that. You can handle everything that they're supposed to have that they normally would, because they cannot enter contracts. So you're doing it for them. All right, next slide.
Conservators.
Oh, Marie, I'm sorry. No, Marie.
It's okay. Okay, conservators must have court approval for all invasive medical treatment. At the public guardian, any procedure that requires piercing of the skin, or sometimes even x-ray, or anything with contrast, we have to go to court and get authority to consent to the medical treatment. Because remember, your conservatorship is for mental health treatment only. Anything medical, typically, you have to go to court for authorization. But remember, if it's an emergency, a hospital can use their internal protocol and move forward with any necessary medical treatment. So if there's any issues up front, you can ask the court for authorization to treat that medical issues, such if you have a conservatee who has diabetes, or who's getting what's the frequent one we have, when they have kidney issues, yeah,
High blood pressure, heart, any of that.
You let the court know, instead of having to go back to court constantly, let you have that power up in front of the conservatorship, so you can move forward with all medical treatment. So the gist is, anything else you need court authority.
Okay, I'd like to just add that if you do need a court authority, something's come up, you can pretty much get that right away. I mean, it's not going to take, 2 weeks to get to court. You can be there within a week usually. And if it's an emergency, you can do it without court authority, but then you have to let the court know.
I'd also like to add a little bit, and that is that I had one of the parents who is a conservator call me and said that she was taking care of her sister, and her sister needed an operation, and she authorized the operation, and who knows how, but that came to the attention of the public guardian's office and the courts, and they were going to take her conservatorship away. And she said, at no time did anybody tell her. Well, somehow she missed that. So this is really critical, because you can lose your position as conservator if you don't follow this.
Right. Remember, your conservatorship is for mental health treatment.
And that's all.
Marie, could you tell them where they should go? I think we brought this up yesterday, but we have people here that weren't there yesterday. Where would they go in Los Angeles? Do you know?
Oh, well, our courtroom has moved to Norwalk, so we're Department A. We're no longer in Hollywood. So you know what, Gail, I have the court clerk number, which may be easier, and I'll give it to you at the end of the session so you can update all
Okay,
our slides. I have the court clerk
okay,
number, the new address, and our new judge name. So we're
okay.
now in Department A in Norwalk.
Sounds good. Thank you so much. I appreciate that. One more thing, you're not allowed to use any experimental drugs. So if they've
No.
come up with something and they're testing it, and UCLA has all these programs, we're going to be testing this. You are not allowed to put your loved one in anything that's experimental, which always makes me wonder, how could they push the COVID vaccination on our loved ones when that is really an experimental drug? So I still can't figure out how they did that, because the law is you cannot do that.
Well, they used it under the public emergency. There's a public emergency clause, apparently, that we found out at the Public Guardian. Because
Oh,
especially
okay.
since a lot of our clients got really, really sick and they needed emergency treatment, the court agreed for not so much of a blanket waiver, but anything COVID related, they moved along really quickly, especially when the conservatee's life was in the balance.
Oh, okay. Thank
But you know
you.
what? But I
Thank
must say, I was in court the other day with our new judge. He scrutinizes everything. Like, we had a petition in front of him for ECT treatment, which is kind of
the electric.
experimental. Yes. He questioned the doctor, like the doctor was on trial for his life. So it's a good thing that this judge scrutinizes everything, but just be ready. If you have a medical issue and you're going in front of this judge, be ready to explain why, your loved one needs it, especially if it's, iffy.
Right. He is a good judge, I hear.
He is. He's
So
very
far,
fair.
that sounds great.
Yeah.
Okay.
All right. Next slide. We kind of went over this just now. So no experiment. Okay.
Yeah.
We've gone over that. That you have if you have it of the estate, normally you'll just be given it of the person, and that's usually all you need. But you can handle the court cases, pay and negotiate debts, request student loan be discharged. And to ask the court to assign you an attorney should you have questions. We've already done that. Next.
Conservator has direct contact with the treating doctor. California Welfare and Institute Code 5328.1. You have the right for prognosis, medication, side effect of any medication, and to have direct contact with a treating doctor. If a doctor refuses to speak to you, you can contact Dr. Amanda Ruiz, and here's her number. And this works really well for doctors inside of county hospitals. When I get a call from conservators who are having issues in private hospitals, I usually tell them go straight to the top, ask for the either the medical director of that hospital or the chief of staff. And I know sometimes doctors can be really, really difficult with conservator, because especially as conservator, you ask a lot of questions. You always want to know what's the best course of treatment. And of course, sometimes doctors feel like when you ask questions, you're questioning their authority. But no, you have that right. And if a doctor does not want to cooperate, reach out to their chief of staff. I don't know if Gail or Jim wanted to add any more.
No, I think that was it. Always go anytime you have a problem. Don't get stressed. Just, may I speak to your supervisor and work your way on up. And as one story I've told, and use your brains too, was don't get stressed, don't get rattled, and carry on, because it's not going to get what you need. Your goal is to get what you need. But there was a case up in Santa Cruz or something. The young man wanted to get a gun and go shoot the police. And so the family called the police department. They didn't tell them that's who they wanted to shoot. But their comment was, well, until he does something, there's nothing we can do. And that is not what the law is. The law is if they have the propensity for it. So they kept asking, and they wrote down everything in their journal, who they talked to, what they said, and their contact information. Went all the way up to the chief of police. He said the same thing. She said, well, that's really not the law, but this person's going to get a gun and going to do that. And when they do it, I'm giving all this information and all the people under you what they said. I'll give it to the victim's family, and I'll also give it to the media. It'll be interesting to see how you spin it. Okay, ma'am, we're going to get them in the hospital. And they did. So think and always keep going up the chain of command till you get the answer you need. Okay, criminal court cases. The public defender, give them that history, symptoms, and gravely disabled if they have a court case, and request that the Department of Mental Health court linkage program, that's the number for it, be involved in the case. They can open the doors for treatment for either jail diversion, AOT, whatever program is necessary. And you can request for jail and or misdemeanor diversion programs, and even felony diversion programs. The criminal court, if they give them an LPS conservatorship, if they're under that, the criminal court has the first right for placement for treatment. Not treatment, but for placement. So if you go, well, I don't really want them to go there, you don't have that right. Criminal court has superseded you on that. But as soon as the court case is finished and you've gained all your powers back, then you have the right to approve or disapprove where they go for treatment, unless it's under the criminal court situation. Okay, next slide.
Real quick, Gail, can I add something?
Yes, please do.
Okay, if your loved one is ever arrested, placed in jail during the conservatorship, speak to the jail team or your loved one's public defender and ask their case to be moved to mental health court rather than any outside courtroom. You want that case to be heard in Department 103. That makes a big difference on the outcome of the case. You know, instead of being maybe sentenced to jail, they may go into, to state hospital or have some kind of other mental health treatment rather than be sentenced, to jail or prison.
Okay,
so always remember.
Is it Department 103 or Department A? Is it Hollywood or Norwalk?
103. Hollywood is just going to handle the regular conservatorship. I'm sorry, Norwalk is just handling regular conservatorship, Department A. But for criminal matters, they're all being heard in Hollywood.
Okay.
So you can have a case in both courtroom, A and 103.
Okay. Thank you. Appreciate it.
There's just a lot of changes going on right now.
There are. I am so glad you're on here with us. Okay, possible treatment programs. The one that gives you the greatest power is your LPS conservatorship, because the essence is to mandate medication. If they are not getting medication, the doctor says they don't need medication, they don't need the conservatorship. The second, a step down from that, would be assisted outpatient treatment. Linda Boyd spoke yesterday. You cannot, by law, have them under LPS and under AOT at the same time. Once, if they're under AOT and LPS is granted, then AOT falls to the wayside. But assisted outpatient treatment is a good program. The people are well trained. Each team handles about 10 people, and they're trained in how to talk with the person. They're very good about trying to encourage that person to do the things that they need to do. The full service partnership, each team handles, I think, 15 people. In my opinion, I don't think they're as well trained or educated as well as AOT teams, but I could be wrong on that. It's a different program. Now, if they're under an LPS conservatorship, they may be placed under a full service program, which provides your psychiatrist, therapist, social worker, whatever they need. And that's very helpful to get them on outpatient treatment, to get them what they need. If they're in an IMD, Institute for Mental Disease, they will not have a full service partnership until they come out of the IMD. Anybody want to add anything?
Also, we have Care Court that's going to be starting up hopefully in December. It's very similar to AOT. I mean, I can't really speak on it because I'm not that well versed on Care Court, but that'll be coming. And it's basically where anyone can make a referral for their loved one to get treatment, but it has to be on a voluntary basis, which we all know is the biggest hurdle.
But they're good about talking to people. And
Yeah.
the Care Court, we had a big thing on that yesterday. Lewis did a good presentation on it, Lewis Lede.
Mhm.
And you can apply it for Care Court. So if your loved one was under the LPS, then they fall short of that. You as a parent or a brother, sister, aunt, uncle, whoever takes care of this individual or is responsible or trying to be responsible can apply for that themselves. Where the LPS, it's usually the treating doctor at the hospital or the jail that applies. So that's, and for AOT, you can apply for that and for full service partnership. Okay, next slide. Medications. Know all the medications your loved one is taking and what you're seeing with it. That's what that journal is so important for. Know the side effects of the medication, the dosages, what's the high and low, and what is your loved one taking, when they're taking it. Some are better to take at night and some are better in the morning. You want to know these things. If there's a problem with the medications, you want to let the doctor know, because remember, you have the power to approve or disapprove medications. If a doctor wants to put a person on 4 or 5 psychotropics, you're not going to know which one's working. Each one has side effects. That person's going to be all over the place. And the worst that I have ever heard was a doctor from Silver Lake had the person on 13 psychotropics. And this was long before we had that many psychotropics. Called the CEO and he took care of the problem immediately. It's important to know the medications. If you call me and you're saying my loved one's still doing this and that, I'm going to ask you what medications they're on. And if you tell me you don't know and you are the conservator, then I hate to say it, but you're not doing the best job as conservator. That is your responsibility. The goal is to find the best medication for clarity of mind with the least side effects. And some of the newer medications are really good on giving people clarity of mind. Now, let me just say something which wasn't in this. Let's say your loved one, the drug dealer, is still contacting them. You can file a restraining order through the court, through the mental health court, to put a restraining order against that drug dealer. Or if it's somebody that's controlling your loved one mentally, a pimp or something like that, you can file a restraining order against them. So I just thought I'd throw that out. Okay, Jim, want to add?
I do. I finally figured out that one of the really good ways to, for me personally anyway, to keep track of all the medications and side effects and et cetera, is I just started a spreadsheet and I listed each medication that my conservatee was on. And then I went to drugs.com online. There's an app as well that's also it's the same, but online you can actually look up the medication, see what are the normal dosages, what are the side effects that are known and so forth. And I printed all that out, printed out the side effects, the dosages and everything. And where that became, and I bound that into a small, 1-inch thick notebook. And every time I went to the doctor to talk to him about medications, I found that really helpful because it gave me a lot of information and insight into the medications. And as well, I put notes on behaviors and effects and clarity of mind and so forth that I observed along the way also. But drugs.com is a great asset, and I recommend taking advantage of it. And that's all I wanted to add. Thank you, Gail.
Thank you. Go ahead, Jim.
It says utilize the scientific method, and primarily that is change one variable at a time. How many times have our loved ones come out of a hospital and the doctor's just done a shotgun effect? There's just a plethora of 2 or 3 psychotropics, 2 or 3 mood stabilizers, and on, and you don't know what's working. So the scientific method is you should change one variable at a time. Get your loved one back to your normal psychiatrist, figure out which medication is the probable best to stay with, and then only change one medication at a time. That way, we'll be able to observe any changes in behavior or clarity of mind. So find out which one is working best, and then you can, add to that after you've reached a kind of an understanding of the clarity of medications on hand. And again,
Yeah,
keep a
I'd
journal.
like to add, yeah. Oh, I'm sorry. I thought you were finished.
No, I was just going to say, keep a journal. A journal is everything. And in my case, I actually incorporated all of my notes right into the spreadsheet. And I could bring them up on demand, or I could print them out as well. But that enabled me to not only track the medication, side effects and everything, but that became my journal as well.
Okay, I just wanted to add, if you want to try a new medication, don't change anything. Just talk to the doctor, and you have to be cautious how you talk to the doctor because they think they're God. You
Yeah.
just say, look, what do you think about if we just add a little bit of a certain medication? And I will give you the feedback, what I'm observing. They're adding it at a small dosage, so you're not going to see a big change. And you know when that medication's supposed to work. Like, is it 3 days, a week, whatever. But you will give them the feedback and let them know what you're observing in your loved one. If it works, then you can start to increase that one and decrease another one. But if you take them off a medication and add a medication, taking them off could add some odd effects. And you're not going to know what the results are. So that old scientific method that you learned back in junior high, high school, utilize that. You probably never thought you had to use that, but it is helpful. Okay, next slide. Formulary for medications. If the doctor tells you that your loved one, their insurance doesn't cover a certain medication, ask the doctor to write a formulary to request the new medication. Now they can, from the pharmaceutical company, they can get free samples. All they have to do is call the pharmaceutical company and they'll give them free samples to try. Or they can get the free samples. They can try them on a small dosage, see if it works. And then if it does, they can write the formulary. The formulary is no big deal. It's 1 page and we've tried this, this, and this. This one seems to work. And the insurance companies almost all the time approve it. You want to seek the medication for serious mental illness. Now, this is my opinion. You have, and I said it yesterday, if I have a headache and Marie has a migraine and I give Marie my Tylenol for her migraine, it won't phase her migraine. It's the same with mental health versus serious mental illness. We're dealing with serious mental illness. So you have to up the ante. The medications that I get a lot of feedback on that really help, one is Invega, and I would say it's 85 to almost 90% success rate. Invega is the same identical chemical composition as risperidol, except how it's delivered in the system. When risperidol goes to the cell, it hits all those organelles, so you get a whole bunch of different messages. And it could be like you're more tired, but you have some clarity of thinking, that sort of thing. Invega goes more to the nucleus of the cell, so you tend to get more clarity of thinking, more motivation, much better. But keep in mind, what medication works for one doesn't necessarily work for another. So you have to kind of be cautious on that. Invega is one that tends to work very well. Vraylar, V as in Victor, Raylar, and that is the only one that I'm aware of that works for people who have negative side effect or negative effects of schizophrenia. That's all the things that are sucked out of them, their personality, their smile. They're the walking zombie. The other medications help with the positive, the things that are added to them, the visuals, delusions, verbals, all that sort of thing. That's kind of the difference. But now there might be others. I don't know. I mean, I do try to keep up on it. That NAMI family to family class has a great class, and they keep up to date on medications. Another one that I have not had anybody in California try, but I have heard from the psychiatrists, several in Florida, is Caplyta, Caplyta, and they swear by it. So I can't really comment because I haven't had any family member try it and call me back. Those are a few. Latuda, Latuda, sometimes is very good. But if you're doing Depakote, Seroquel, Ativan, and I will tell you that when people call me and they're telling me my loved one sleeps a lot, they have delusions, they're this and that and all this other stuff, I can say they're probably on Depakote, Seroquel, Ativan, Adderall. And they say, yeah, how'd you know? Because those help people with mental health problems, in my opinion, because I am not a doctor. But it doesn't phase a person who has serious mental illness. Zyprexa tends to blow people up like a balloon. Only one time have I had in 20 some years a person say it really helped my son. Only once. So it's the probability of that one. I wouldn't jump up and down for that one. Okay, do not, when the doctor says, well, this is the best you're going to get, you're just getting pushy. Do not settle for just okay. You want your loved one back to their old self, as close as you can possibly get. So push for it. And if it means trying new medications, remember, you keep everything the same. You just add a small amount. And if you see a positive change, then you can go for it. All right, Jim?
Nope, I think we're there. Covered this.
Okay. Marie?
Yes, placing the conservatee in a treatment facility. ICD, the intensive care division of Department of Mental Health, evaluates and suggests where the person should be placed. So for those of you who are not familiar with ICD, we call them our gatekeepers. They're part of DMH, LA County Department of Mental Health. And the reason why they're the gatekeepers, they evaluate for placement, and they also pay for a lot of the beds in mental health facility. The county has contracts with the IMD state hospital, and the group or the department who control those beds or who pays for the bed is ICD. So if your loved one is in a higher level of care above boarding care, their bed is typically going to be paid for by ICD and DMH. So if ICD contacts your facility, and they have a bed available for your loved one, ask questions. Try to visit the facility, see where it is. Look at the other residents, talk to staff, see if this is a good fit for your loved one. As a conservator, by law, your request for placement to a facility must be honored as best as possible. Write on every contract, when your loved one's admitted to a facility, write on every contract, your express written permission must be given for any change in medication, treatment, and placement. Remember, as the conservator, every facility should have a copy of your letters of conservatorship, the court order that's given to you when you're appointed by court. Also, when you do give them a copy of your letters of conservatorship, make sure you give them a good contact number for you. A lot of times we get calls from facility or treatment teams who want to get private conservators removed because they can't find them. They don't have a good number, they don't have an address, or the conservator is not responding to them. So remember, one of the most important things when you place your loved one at a facility, give them your letters of conservatorship and give them a good contact number, and write in the chart that your express written permission must be given for any changes in medication, treatment, and placement.
Okay, if I can add one more thing,
Mhm.
ask questions when you tour these facilities. When you talk to them on the phone, talk is cheap. So you really don't always trust what they're saying. For instance, we went to one facility and they said they had a library. And above one of the rooms, there it said library. I looked in there, there was a desk and 3 books. I said, that's your library? Oh, yes, that's our library. That's not much of a library. The other thing you want to ask, make your list of questions. You want to know about treatment, therapy, groups, when they have these, how often they have them, family get-togethers that you can get together. And another one is sex. You don't want to have your loved one coming out and you end up having to be a grandmother or grandfather at this time. So ask what their rules are pertaining to sex. They cannot keep people from having sex, but they can do their best to kind of monitor as best as possible. Okay, Jim, you want to add anything?
No, I think that's well said.
Okay, next.
Placement and treatment via hospital. Hospital requests intensive care division, ICD, to evaluate conservatees for placement. Person can only be transferred from a lockdown facility to another lockdown facility. Institute for Mental Diseases, IMDs, is a lockdown facility where the hospital will first discharge the patient. As patient improve, they might skip the IMD and be discharged to an enhanced residential housing. It's actually enhanced residential setting, ERS, which is a term you'll hear from ICD, which is a secure treatment facility. So remember, once your loved one is at the acute hospital, they typically wait for a bed to go to an IMD. And once they finish their treatment at the IMD, they go down to an ERS, which is like halfway between an IMD and a boarding care. It's still secured and they're still getting a lot of intensive treatment, but it's a little bit more open. And once they're done with their treatment at the ERS, they go down to a boarding care or they go home, whichever course of treatment is best for that person. Gail, did you want to add anything?
No, I think you did well. The one thing that I would say, if you can avoid them coming home, that might be a good thing. You have to judge each one on your own, each case on your own. The reason why, if they come home, remember when your kids went off to college, geez, they managed to wash their own clothes, do all their own work and everything. But when they come home, they bring a bag of dirty laundry, drop it off and say, hey, mom, my laundry's in there, when's dinner? They revert back. So you want them to stand on their own 2 feet as best they can. So sometimes even in an apartment, if they have a roommate or a board and care, something like that is sometimes more preferable than having them come home with you, because it disrupts you and you do need a life of some sort so that you can continue to care for them. Okay? But if you take them home, that's your decision, and that's not a bad decision either. You have to judge that case on your own. Okay, that's it. Jim, did you want to add anything?
No.
Okay.
Don't worry, I'll jump in if
Okay.
Marie, this is yours.
Okay, treatment and placement via jail. If your loved one was in jail and was facing some serious charges, most likely they'll be placed at a state hospital. In Southern California, our 2 main state hospitals are Patton, and this is in Highland, and San Bernardino, and Metropolitan State Hospital, which is in Norwalk. So if they're going to a state hospital, most likely it's because they were not going to jail, which is a good thing because they will be receiving mental health treatment at the state hospital.
And those facilities are not bad. They really aren't. Patton especially, I understand, has really good treatment programs. They offer them music lessons, writing lessons, education, all sorts of things. So some of these facilities are not bad at all. Okay.
All right, so we're looking at in this slide how people are transitioned from one facility to another And the basic rule is that you can, in terms of how restrictive the environment is, you can move from side to side, or you can move down, but you can't go up. So you couldn't go from a board and care, let's say, up. It would have to be to another board and care. But in this case, we're talking about an Institute for the Mental Disease, an IMD. It's a lockdown facility, and also an enhanced residential housing secure facility, and a board and care, which of course is the least restrictive. You must go from lockdown, hospital or jail, to lockdown. The conservatee may skip a facility and go to a less restrictive facility as they improve in their recovery. So in other words, let's say they're in the hospital and they're really improving, they could just go right on down into a board and care, which is often the case. But sometimes they are going to go from a hospital to an IMD, and just remember that the transition is always sideways or down, but you can't go back up to a more restrictive environment.
Unless you go to the hospital first and the hospital holds you for an IMD. That would be the only exception.
Okay. Next slide.
A doctor can request that the court remove you as conservator. So sometimes at the public guardian, we get calls from hospitals or facilities that, like I mentioned earlier, the main one that we get is when they're not able to reach a conservator. They want to know, how do we remove them because we can't move forward with treatment without their help? Or if the conservator is unreasonable, especially with treatment, medication, or wanting to try experimental treatment. Like sometimes we do have loved ones who want to try cannabis or other not so scientific treatment of their loved one, and it kind of clashes with the treatment team's plans. So they can ask the court to have you removed as a conservator. You must be reasonable, or the treating doctor can request the court to remove you as conservator. You can also change a treating doctor. If you're having issues with that doctor, especially, it's your right as a conservator to ask for someone else to be appointed to treat your loved one. Gail, did you want to add anything else?
No, I think that's covered pretty well. Okay, conservatee's loss of right. When the conservatorship is granted, they temporarily lose the right to drive a car, enter contracts, and to determine where to live. Those can all be granted back to them. They cannot be granted back the right to refuse medication. If that is, there is no conservatorship. So in that paper that we talked about, that pamphlet way back at the beginning, it has the form that you get the doctor to fill out so that they can start driving a car, because the whole goal is to get the person so they can get their life back. If they want to get a job and they might have to drive a car, maybe delivering things or something, then it would be important for them to be able to drive a car. But when you think that they're ready for it, you notify the treating doctor, write them a letter. The treating doctor fills out the form, it's presented at court, and then usually DMA, sometimes they will do their own evaluation to make sure that the person is ready for driving. And their evaluation is like, give me your name, rank, and serial number kind of thing. Okay, the right to enter contracts, that's important too. We had a case where a young man got married and he had to enter the contract, so we needed that right back. He also, the public guardian was a conservator, and they can only put him in state sanctioned facilities. So he had to go to court and say he wanted his fiance to be the conservator. So because they were getting married and he wanted to be able to live with her. He couldn't have lived with her if the public guardian remained as the conservator. By the way, that couple's doing very well. Okay. The more permanent restriction is the right to shoot and possess a gun. And that, I think, is federal. So, and you really don't want them getting that right back anyway. Okay, anybody want to add anything? Okay, next slide. We're moving right along. Okay, the reinstate the rights of the conservatorship. I talked about the right to drive a car. When you think they're ready for it, the right to enter contracts, the same thing, just write a note. And it doesn't take but maybe 7 days to get to court and get these rights approved, but have a good reason for it. All right, not that I need for them to do a bunch of errands around the house, but sometimes that may be it if they're
Yes.
helping to take care of another person. Okay, next. The renewal of the conservatorship. Oh, that's Jim and Marie.
That's okay. Well, primarily the thing that I see is oftentimes parents wait to the last minute to file, for the renewal. So you really do, when your conservatorship papers are approved in the beginning, you need to mark that on your calendars. 3 months prior to it expiring is the point that you should have the forms in hand, which is called a declaration stating that the person is gravely disabled, that you'll then take to 2 doctors. It can be a psychiatrist, 2 psychiatrists, or it can be a psychiatrist and a doctor, or just 2 doctors, as I understand it, and get those signed. If in fact your loved one needs to remain on conservatorship, the first thing you do is to have the 2 doctors sign that and make the statements in their professional opinion that your loved one needs to continue on in the conservatorship. The doctor's declaration stating the person is gravely disabled is one of several forms that has to be filled out. I know here in Orange County, we actually have training classes on how to fill those papers out as well. We have those forms readily available. For Orange County, if you're from Orange County, you can contact me and I'll provide you the forms. I'll just send them to you PDF and you can print them out. Gail, or excuse me, Marie, would you like to add to that?
Well, keep in mind, we just moved to Norwalk and the court is kind of upside down now. So you really have to have your papers ready to go. 3 months, get your doctor's declarations, be ready. And even when you do get your court date, call the clerk. I mean, maybe a couple of weeks before your hearing to confirm that hearing date, because what we've seen is some of our hearing are changing because of the calendar and we don't get a new date. We have one date, but the case is being heard on another date. It never hurts to call the court clerk to confirm your hearing date. And please get your paperwork in ahead of time.
Okay, as some of you might be freaking out, my loved one's only seen 1 doctor. Those psychiatrists and psychologists usually have someone else they're working with, and that person can do an evaluation on your loved one, and they usually say, okay, I'll get so-and-so to do the doctor's declaration for you. But if you go to court and they're contesting it, be sure that doctor has seen that person not that long ago. Because if they ask, if the public defender says, okay, when was the last time you evaluated this person or you saw them? Oh, it was 2 months ago. That doctor's declaration won't stand. So if they are contesting it, be sure that doctor, one of them at least, has seen that person just recently. And sometimes if you get to court and there's a problem, you can ask the court to give you another evaluation. Their doctor's sitting around the courthouse all over, and they'll appoint one of them to do a quick evaluation on them and write it up. So that's another, but don't wait for that one. That would be kind of a little hairy if you ask me. Okay, next.
Oh, Marie and Jim. Gravely disabled. Mary, why don't you go ahead and cover this? I think this is your turf. It's best if you get into this.
Okay, remember, grave disability is the inability to provide for your basic needs of food, shelter, and clothing because of the mental illness. So during your reappointment, the doctor must point out that your loved one remains gravely disabled. And again, that's the inability to provide for food, clothing, and shelter because of a severe mental illness. Basic needs addressed as basic needs are addressed as safety and health risks. I don't know if you wanted to speak more on this.
Well, some of the ways that we look at this is shelter. They have no place to live safely. They cannot handle a board care or shelter. Now, we had a case that Connie Draxler told us about where the young man went to court and he told the judge, Your Honor, I can handle my shelter, food, and clothing. I can get a tent from the city, go live on such and such street. I can eat 5 times a day at the food banks, which is true. All that's true. And I can get all the clothes I want at Salvation Army. The judge had no alternative, but he had to release him because he had a viable plan. Not something we like, but he had a viable plan. Now, if a family member or somebody responsible had been there and said, yes, he can go and get a tent and live on such and such street, but he victimizes people or he's victimized himself. It's dangerous for him. He can eat 5 times a day at the food banks, but he's lost significant weight because he's not doing it. Or likewise, compulsive eating and blowing up like a balloon. And he can get all the clothes he wants, but he wears his clothes for excessive periods of time. And he dresses inappropriate for the weather or even takes his clothes off at inappropriate times and places. You only need one of those: food, clothing, or shelter. If you can state one of those, then the judge would have something that he could have ruled on and said, yes, this person's considered gravely disabled, so LPS is granted. So it's important for that judge to have what they need to be able to rule on. Okay, that's it.
Okay, so at the time of reappointment, if your loved one does not submit, meaning they don't agree to renew the conservatorship for another year, they can ask for a court hearing where the judge will decide whether or not they remain gravely disabled, or they can request a jury trial where 12 people decide whether or not they're gravely disabled. So again, one of the things we lost during the pandemic, unfortunately, that we've noticed after the fact with the public guardian is that when the conservatee doesn't come to court, the judge misses that aspect of seeing how they truly are, whether they're dressed in layered, they're malodorous. So we lost a lot of hearing because of that. So we're starting to ask for our conservatees to be brought back into court so the judge and jury can see them. So I don't know if ever one of your conservatee does not want to submit and wants to contest the conservatorship, maybe bring them into court, let the judge see for themselves rather than appear on WebEx how your loved one really is in person. And I don't know if Jim, if you saw that in Orange County during the pandemic.
No, everything was online to my knowledge.
Yeah.
No.
And it kind of, like I said, it kind of took away from seeing our conservatees, how they really are in person.
Mm-hmm. It's important for them to be in court if it's possible, but the doctors don't have to be, which is a new thing, which is nice because it was a problem for a while. The doctors didn't like going to court because they'd sit there all day waiting for their case. And they had other clients they had to deal with. So that was a real problem. So the pandemic did actually may improve the situation where they can do WebEx for the doctors now. And a jury trial, by the way, that is very, very stressful because you have to convince 12 people to agree that your loved one is gravely disabled. If you don't have 12, you don't get the conservatorship. And when you are doing this, you want to be sure that somebody's not a Scientologist. They don't believe in this. And you can't ask, are you a Scientologist? That you can't do, but you can ask other questions. But it's possible to get it. It's just very nerve-wracking. Jim?
Okay, so we're on to the next slide, and it basically it's talking about what happens when a conservative goes AWOL. If they're just AWOL, then you know where the person is. Right in the Welfare Institution Code, it states that the police then have that authority to pick up that person and return them to the facility. If they're in fact missing and you don't know where they are, grab your pencil and write this down. It's called outpostforhope.org. Again, that's outpostforhope.org. And it really is a phenomenal piece of work done by a gal back in Florida that was looking for her lost sister for years. And she provides so much information, all the steps and so forth, what to do, where to file and how to file. So basically you want to understand that you don't have to wait 24 hours to report your loved one as missing because of their mental health. They're considered disabled. And so the law requires the law enforcement to take your report and act on it immediately. So call your local law enforcement, let them know that your loved one's gone missing, give a copy of your conservatorship papers to them as well. And it says any individual or person with serious mental illness goes right to the top of the missing persons list under the missing children as a dependent adult. So, and they don't have to be under conservatorship as well. One of the things that I have had experience with is a gal that was sent to me by Outpost for Hope. And she called and reported to me that her son was out here in the Anaheim area, to the best of her knowledge. And basically, she was having difficulties filing a missing persons report with the Anaheim Police Department. I contacted somebody I knew that was a chief of police in Tustin, and they said, no, that's not what the law is. They have to take that. So, and just recently, another family contacted me, and we've been trying to find their daughter for some time now. And again, that the Orange County Sheriff's Department said that she really, they took the report, but she should have contacted her own police department from where she was calling. And that's just not true. If your loved one's missing in let's say Mission Viejo, you can contact whatever law enforcement authority is responsible for that immediate jurisdiction. You don't have to live there to file that. So just know that. But you definitely want to become knowledgeable about how to find somebody that is missing. And
Right.
there's a lot of people that go missing every year. Next slide.
But
Can
what-
I
let me
add something real quick? I'm sorry.
Hot topic.
Free.
Oh, I wanted to say, if your loved one is at a facility, the facility must file the missing persons report as they were the last ones to see them, unless you were with them. But you know what? You really need to get that missing persons report filed ASAP, and always have a picture of your loved one to give the police. Also, when our conservatees go AWOL, one of the first places we go is the Sheriff's Inmate Locators website. I would say 1/3 of the time they've been picked up, and you'll find their information there. It's really a self-explanatory type of website. So it's LA County Sheriff, and you go in there and click Inmate Locator. And also another thing that we do is we call all surrounding hospitals with a psych ward, just to be sure that your love, that our conservatee wasn't admitted under John Doe or what have you. So always remember, Sheriff's website, file the missing persons report, call local hospitals.
We can't call local hospitals because if they're
As a
under-
conservator, you can.
Yes, you can. You're right. I forgot about that. Okay, I'd like to also add one more thing. While your loved one, before they go missing, if you can get their DNA, don't grab a fistful of hair and yank it out of the head. But if you can get a little bit especially with the root, or take a swab inside their mouth, a cotton swab or something like that, put it in an envelope. Do not put it in a Ziploc and seal it, because then it can create mold and it won't do any good. But you want it dried out. That's why an envelope, a paper envelope where you're not closing it, so that it can dry out. But try to have some of their DNA. God forbid something bad should happen. It could give you closure rather than always wondering. And I mean, this sounds awful, but those things, they do happen. And we all freak when our loved ones are missing. So do that. Also, if they're under a conservatorship, and Marie, you were telling us yesterday, if they're gone for 60 days, then the conservatorship is terminated. You want to address that, Marie?
Yes, so after 60 days with the public guardian, if our conservatee's gone missing, because you're not able to act or serve, the conservatorship will end. Especially if your loved one goes AWOL around reappointment, if you cannot find them and have them come to court or get them evaluated, your conservatorship is going to end. So that's why you must act immediately. And even if you're close to conservatorship and your loved one is AWOL, ask the judge to continue your case, because you can get a continuance for maybe a couple more months in the hopes of locating your loved one. And I also
And
forgot to mention at the beginning of this class, always have multiple copies of your letters of conservatorship, because you're going to be passing them out everywhere that your conservatee goes.
Mhm. And just one more thing, take a picture, even if sometimes they don't want you taking their picture individually, but take a picture like the family. So you have recent pictures of them all the time, group pictures, this and that, whatever, because you can dub everybody out and just have them. But those pictures are really important. Okay.
I will add, what Gail talked about, having a sample of hair. Just recently, I had an individual call me who was looking for her sister, and her sister was found deceased, and it was, the coroner did a really bang up bit of research to find the family and was able to locate the family and notify them. But it was the DNA that really made the difference. And so that's just reality. There are literally tens of thousands of Jane and John Does buried in cemeteries across the United States. And I shudder to think how many of those passed away, as individuals suffering from a mental health condition. So it's really important. It really does provide closure to the family. And you're not, because it's just horrible. You're wondering what has happened to them. I know right now we're looking for a young lady. And I think, my gosh, she's out on the streets. It's cold. How do we find her? Several cases, actually. But anyway, enough. It's just very important to take the DNA samples. All right.
Jim?
Next slide. Oh, we're there.
Yours.
I didn't see. I blinked. I didn't see the change. Forgive me.
Oh, I think we skipped one.
Okay.
We did.
Even the state of California.
Okay.
Here we are.
Thank you.
Okay, so remember, your LPS is a specific law to California. That means if your loved one winds up in Arizona, New York, or wherever else out of state, you have no powers in other states. These LPS laws, remember, are only good for California. However, if you need to take your loved one out of state, you can contact the court and get special permission to take them out of state. Typically at the public guardian, when we have a conservatee who needs to go out of state for a wedding, a funeral, or visit family, we write a letter to the judge. We let them know client such and such will be leaving for, let's say, whatever state, Arizona. He will be attending his sister's wedding. During that time, he will have the escort of another family member, and that same family member will be giving him his medication daily. And once the wedding is completed, such family member will be bringing him back to the state of California and returning him to the facility. So you have to really be specific in your request to the court to go out of state. And it's typically granted. If you have a good plan, your loved one's mental health needs are going to be addressed, it's going to be granted. So also presently, California does not have reciprocity with other states, meaning that you can't move out of state and transfer your conservatorship. It's only good in California. Remember, LPS are WIC code, meaning state laws that only apply in California.
Likewise, people from other states who have a guardianship or conservatorship for their loved one who has mental illness cannot come here and convert it to an LPS. They have to go through the whole system just like we do. Okay, Jim?
Okay, so basically, we thank you for your determination and endurance to help your loved one. When you think you've had enough, you can still give 10% more. That's the Navy SEALs model or slogan, you might say, that they use. But But there again, the Navy SEALs have never walked in our road, have they? So keep strong, take care of yourself, maintain your sense of humor, as Gail always says. You are your loved one's strongest chance for recovery. No one's going to care and have the compassion and motivation to help them like you do. I want to thank everyone for coming today. Gail?
Thank you, everyone. Is that the last slide?
Yes.
Yeah.
Oh,
Oh my
please
God.
consider donating.
Yes, if you would, if you have the means and the ability, we would really appreciate for you to donate to NAMI Urban LA. That's the address. Note on your check or whatever that this is for LPS Conservatorship, or you can call NAMI Urban LA and do it through a charge card. We would really appreciate it. We use this to help to continue these classes. But if you don't have the means, because sometimes when you're dealing with mental illness, it drains you, please do not. Only if you have the ability and the means. But thank y'all so much for coming. Hey, we did this in record time. That was pretty good. I hope y'all got a lot of information.